luckily, like ARP, for instance, if you live in the DC area, Legal Counsel for the Elderly can help you actually do a lot of these long-term planning documents like your healthcare power of attorney, your financial power of attorney, for free if your loved one is as an AARP member, and they can help you get those things in order and explain what those documents are about. The Alzheimer's Association can also connect you with their legal and financial planning workshop presenters if your loved one has been diagnosed with Alzheimer's or related dementia. So those are tools that you want to look at, and preferably as early in the process as possible. If you can't begin it early, again, that phrase, just as early as possible. Once the diagnosis comes, delaying and waiting isn't going to help alleviate the obstacles and challenges later. This is a great question, as are all of the questions that have been raised today. So HIPAA laws, you may have heard of, govern patient privacy. So, and it's a good thing that they exist. Fortunately, providers can't just hand out your or discuss your healthcare information with just anyone. But caregivers obviously do need to talk with providers, especially when the people that they're helping to provide care for can no longer make decisions or communicate on their own behalf. So what the providers will need is consent to be able to release information to you. So if you've ever gone from one doctor to another doctor, your new doctor will ask for your medical records and your old doctor will ask for a release to give those records to your new doctor. That's essentially what happens whenever a caregiver asks for information or tries to or needs to communicate with a healthcare provider about their care recipient. They need to have some type of consent, and providers will generally have some type of form that the patient, the care recipient can fill out. And that's fairly straightforward. The tricky part arises when that person is no longer able to communicate on their own behalf, or they're no longer deemed to have capacity to make their own decisions. And in that case, hopefully you've had conversations ahead of time, and the patient has designated someone as their healthcare power of attorney, not to be confused with your durable financial power of attorney, because just because you have authority to talk to the bank doesn't mean that you have authority to talk to the doctor. These are two different things. So you want to make sure that you've, as early as possible, gotten the healthcare power of attorney, and there are form documents that you mentioned. Like I said, if you live in the DC area and you're an AARP member, Legal Counsel for the Elderly can help you draw one of those up for free. The trickiest part is when the window has passed for the patient to be able to create a designated power of attorney. Just like with a will, just like with a financial power of attorney, a healthcare power of attorney can only be granted when the person has legal capacity to do so. And if that's lacking, if that capacity doesn't exist, it makes it much harder for the caregiver. And you have to go through steps like possibly even guardianship through the courts in order to be able to get authority to do certain things on your loved one's behalf, which is why it is so important that people make these arrangements as early as possible. Just because you're creating a power of attorney, you're designating your power of attorney now in case something happens 5, 10, 20 years from now, doesn't mean that the person that you're designated can go, get into your bank account or go talk to your doctor. You can, the documents can specify that their authority only springs into action when you've lost capacity. That way you can assure the person who's the patient, the care recipient, can be assured that their autonomy is preserved for as long as possible.